Whoa!
I filed my eligible obligation.
What are you talking about? What are you talking about?
I'm talking about eligible obligation on the
What?
USCA.
Oh, you talking all that kind of stuff. I'm striking all that. If I hear it again, I'm not going to let you represent yourself. I promise you.
Oh,
That's enough. I don't want to hear another word.
okay. I like to also.
Another one? I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush.
All right, guys, today we've got a sovereign citizen facing a possible 30-year sentence. Yeah, you heard that right, 3 decades. And instead of hiring a lawyer like any reasonable person would, this guy decides he's going to represent himself. At this point, it's either extreme confidence or complete delusion. Either way, it's a risky move that doesn't end well. The judge shuts him down hard, and what follows is pure courtroom chaos. Seriously, though, why would anyone try this when their freedom is on the line? Let me know what you think, and let's get into it.
All right, Mr. Baker, you're before the court day for your arraignment. And let's see. You're not. Have you hired an attorney?
No, sir.
Do you plan on hiring one?
No, sir.
Are you going to represent yourself, or do you wish
Yes,
to have
sir.
a public defender to represent you?
No, sir. I'm gonna represent myself.
All right, you're before the court today for your arraignment. You've been charged by way of an information with possession of a cocaine, possession of a controlled substance, count 1 and 2. Those are both third-degree felonies, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. You have a count 3, which is fleeing or attempting to elude high-speed reckless. I believe that should be a second-degree felony, punishable to 15 years in the Florida Department of Corrections and a $10,000 fine. Count 4 is drive my license, cancel, suspend, or revoke third or subsequent offense. That's a third-degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. And count 5, possession of marijuana less than 20 grams, which is a first-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. So you're looking at a total of about 30 years in the Florida Department of Corrections if you're convicted of everything and you get the maximum sentence. And you're still wishing to represent yourself?
Yes, sir.
How do you sit there, hear that you're facing 30 years, and still confidently say you'll represent yourself? It just doesn't make sense. Maybe pulling the sovereign citizen argument on a minor charge is one thing, but this is serious time. At some point, reality has to kick in. The court isn't going to entertain made-up legal theories, and history shows these defenses fail every single time. Yet here he is, doubling down, potentially throwing his entire future away. Do you think he believes he can outsmart the system, or is this something else entirely?
Or if you'll raise your right hand to be sworn in.
Yes, sir.
All right, Mr. Baker, state your name.
Lee Baker.
And Mr. Baker, you have asked to represent yourself. Is that correct?
Yes.
How far did you get in school?
9th grade.
Okay. And so you can read and write?
Yes.
Okay. Are you employed?
No, sir.
All right. How do you make a living?
I'm unemployed right now. I was living with someone else.
Sir?
I'm unemployed. I was living with someone else. I just got out of jail about 5 months ago.
Okay. Well, what is your trade?
I have my own business,
All right. What kind of business?
a cleaning business.
Okay. And have you ever represented yourself before?
Yes.
All right. Let's see. Are you under the influence of any drugs or alcohol today, which would affect your ability to make this decision to represent yourself?
No.
Have you ever been diagnosed with a mental illness that would affect your ability to
No,
to make this decision?
No.
All right. You understand that attorneys are trained in the rules of evidence, criminal procedure, and the law, and they're there to assist you in preparing pretrial motions, preparing for pretrial hearings, and to participate in discovery, and also preparing for trial.
Comprehend that very well.
All right, and sir, you understand that if you're representing yourself, you'll be held to that same standard.
I comprehend that.
All right, and I cannot assist you in any way. The state attorney would not be able to assist you in any way. Is that correct?
I comprehend.
All right, and you still wish to represent yourself?
Yes.
All right, Madam Clerk, if you'll print out the information, and Deputy Dexter, it's okay if the clerk hands the information to Mr. Baker? All right, Madam Clerk, if you'll do that. Mr. Baker, when you receive that information, I'm going to ask that you enter a plea at this time.
I like to file 2 motions on the record as well, sir.
I want to do your arraignment first.
All right.
All right, whenever you're ready, you'll let me know and you enter your plea.
I enter a plea of not guilty.
Okay. All right, you're filing motions?
Yes, sir. I got
You have copies for the state.
yes, I do.
Okay.
I got a declaratory judgment, and I want to furnish this bond to the clerk
You file it. Go ahead.
for my release from the Bay County Jail today.
Okay.
That's declaratory judgment. That's for the clerk only.
Now, you providing a copy of the state, everything you've given the clerk?
The bond, I shouldn't have to give the bond. The bond goes straight to the clerk.
Anything you file that you want me to consider, you have to provide a copy to the state, sir. That's you're representing yourself. You have to know those rules. If you don't, you're going to mess up.
That.
If you're not providing to the state, I'm not going to consider it.
Okay.
And the clerk doesn't make any determinations on that. All the clerk determines is whether you're innocent or not.
I'm not talking about the bond for the declaratory judgment. I'm talking about the bond for the clerk to release me today. I filed my eligible obligation.
What are you talking about?
Sir?
What are you talking about?
I'm talking about eligible obligation.
What?
On the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. And if I hear it again, I'm not going to let you represent yourself. I promise you.
He actually brings up USCA, referring to the United States Code annotated, but it's clear he doesn't really understand what he's saying. This is a common move, throw around complex legal terms hoping it somehow changes the outcome. But that's not how any of this works. Then he goes into this eligible obligation idea, another baseless theory claiming debts or charges can just be wiped away. Courts have rejected this over and over again, yet he acts like he's discovered some hidden loophole. At this point, you have to wonder, does he truly believe this, or is he just trying to confuse the judge?
He's already entered a not guilty plea. We'll set this for a pre-trial. We'll set it for don't ask me any questions like that, sir. I'm not answering any questions. If you want to file a motion, file your motion. We'll set it for our December, when's that motion day in December? December 19th at 9 o'clock. Sir, you may, if you're going to do the sovereign citizen and all that, you may want to consider having the attorney.
I'm a private citizen, sir. I'm not a sovereign citizen. I'm a private citizen.
Listen to me. If you're going to pursue that, you may want to reconsider representing yourself.
No, sir.
But I'm not going to pay attention to any of that, and I'm going to strike all that.
Okay.
So we'll see you December 19th at 9 o'clock.
It's no problem. Oh,
That's enough. I don't want to hear another word.
okay. I'd like to also.
Another one? I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush. Whoa. Mr. Baker, I'm going to appoint the Office of Public Defender to represent you. I'm going to find that you're not competent to represent yourself at this time. I'm going to reverse my decision. The Office of Public Defender is going to represent him. We'll keep it on that December 19th date. I just did. Come on now. Y'all close that door where I can't hear him or he gets in any more trouble.
Honestly, the judge stepping in might have been the best thing that could have happened here. Some might call it harsh, but what was the alternative? Letting this continue while the case completely derails? The judge recognizes the situation for what it is and forces legal representation, essentially preventing further damage. There's a limit to how much nonsense a courtroom can tolerate. In the end, this wasn't just about control, it was about making sure the defendant had at least a chance at a fair outcome. If you enjoyed this breakdown, make sure to like and subscribe, and I'll see you in the next video.